who's familiar with John Bedini? Just about everybody, right? And so I started looking at, who are the attorneys involved in everything, and I tried to, email and find contact information, and I came across somebody's bio who had been involved and sent an email and asked him if he would, be kind enough to share some of his expertise and share it with us this weekend at this conference about the patent process and, maybe a little bit of his involvement with John Bedini's patents. And his particular office is over in Seattle, so, we're basically neighbors. And he received a BSEE, and what is that? Bachelor of Science in Electrical Engineering. And from Gonzaga, and we had a little conversation yesterday about Gonzaga and the basketball team and all that kind of going on, and it's really getting the Spokane area kind of well known nationwide. Well, Kevin went to Gonzaga over in Spokane, and so he specializes in patent law with a focus on patent portfolio development and patent prosecution. And so please help me welcome Mr. Kevin Jablonski.
Thank you. We're going to talk about the useful arts. When we say the useful arts, we're really talking about patents. That's the useful arts. The non-useful arts apparently are like copyrights and music and art and all the rest of that. I don't really think that's true, but for whatever reason, we call this the useful arts. This presentation is going to be a high-level overview of utility patent prosecution practice. Now, utility patents are distinguished from design patents. Design patents start to creep over there into the non-useful side of things. Guide to being aware of patent law principles is another tenet that we're going to be working through. A guide to general awareness of patent prosecution pitfalls, and then perhaps a series of questions that non-practitioners might ask. I'm decently open to questions as we go through, but I have some slides at the end that will be those questions in case you don't ask them. This fellow Hopkins probably just went to the patent office and said, I got an idea, and they probably said, you got it, there you are. Samuel Hopkins, an apparatus and method for an improvement in the making of potash and pearl ash, commonly used ingredients for fertilizer at the time. So that was the very first patent that was ever issued by the United States Patent Office. It didn't even have a number, because why bother with that? That's Hopkins' patent. Which one? Yeah, Hopkins. So it's expired now. You can. Well, how about this one? This is one of the ones that I prosecuted from John Bedini that issued on September 19, 2006. Now, during this time frame, the law had changed, so patents didn't last 17 years from date of issuance, but rather 20 years from the first date of priority claim. And if we look deep into here, we can find out that it was filed March 26, 2002. So we think that that is going to last until March 26, 2022. And then this one is currently in force and enforceable. Common aggressive patent practice usually involves filing several continuation applications. I talked about the Limmelson thing before. They kind of shut that down where you can't keep doing that in perpetuity because of the 20-year from first filing date. But it's still a good idea while you have this 20-year period. If you've got some sort of very innovative, very base level, move the whole industry forward type of idea, maybe it's not just enough to sit on that one idea. You got this filed and you get a patent, but while it's still there, file a continuation. And maybe we get just a slight nuance of the claims going. And after that, maybe another slight nuance. We always just want to have one open, because maybe somebody else came up with another idea that might have improved yours, but it's still able to be described within our initial disclosure, to where we'll just write a set of claims that read exactly on what they just did. And now we have that for them to deal with. Maybe we can't actually get it, maybe we don't have enough description, but at least we have some kind of weapon in our arsenal to go after them with. So generally a good idea to keep patents open if it's that important. Software as a patent, we talked a lot about that, and I'm not going to talk any more about that. Well, I talked a little bit about the money earlier, right? That I think it's a good rule of thumb estimate. The overall cost of obtaining and maintaining a patent in the U.S. over its 20-year lifespan, I always say about $20,000 to $50,000 when it's all said and done. That you got to think about, what am I going to do with that? That's an expensive piece of wall art if you're not really going to exploit it for commercial purposes. So I think a patent is not a guaranteed path to making money. What you do is say, I've got some ideas that I think are marketable, and maybe they can be protected through patents, but that's going to cost me a decent amount of money over the course of some time here. How am I going to make that back? So I prefer to call it a way of protecting making money. It's not really protecting the idea, it's protecting your channel of income based on those ideas in the first place. If there's no way to make money on it, I think don't spend $30,000 to $50,000 on that.